All right, let's go ahead and begin. Welcome to an oral argument session of the Fifth District Court of Appeal. I'm Judge Cohen, and I'm honored to be joined today by Judge Rand Wallace from Orange County and Judge Jim Edwards from Seminole County. We've got the case of Fortini versus De Palma, 20-121. We are recording this and streaming it live on YouTube. But if large groups watching you makes you nervous, you shouldn't be nervous. So let's go ahead and proceed.
Good morning, Your Honors. May it please the court. I'm Bill Gressley from Jacksonville on behalf of the appellant Marco Fortini. I have an aspirational goal of 5 minutes reserved for rebuttal. That rarely works, but let's see. Your Honors, I'm assuming that you're aware this order that we have under review here arose out of the final judgment of dissolution of marriage that was on appeal, prior appeal for this court. I tried for months, and the court indulged me up to a point to hold that appeal in abeyance until this order could get entered because it was contemplated by the final judgment. But it took from April until August to get a hearing for the second part of this procedure. So it did not happen. So we are considering this on its own without really any context. The record from the initial appeal has
well, if it means anything, Mr. Purcell, I was on that earlier appeal, and B, we always have the option to take judicial notice of our own records. And so I am very familiar with the facts, the underlying facts. And I know that Judge Wallace and Judge Edwards are very familiar with the underlying facts as well.
And I assumed that would be the case. I just wanted to point out that this is part of an ongoing procedure. The real reason that I had asked that the court maintain the record from the initial case was simply so that if there was any question about what had transpired, then we could easily answer it. The reality is that the facts were not so much in dispute in the prior appeal or here. The legal consequences of those facts is what really is driving this. And the first issue I have raised, and what I'd like to begin with, is simply the rule that governs the appointment of a receiver, and the trial court's finding that the receiver didn't have to comply with this rule because of, quote, impossibility. That is, to me, a conclusion that cannot withstand scrutiny. Number one, there's nothing in the rule that gives any discretion unless the court orders something else. The receiver is supposed to file an initial inventory within 20 days. And then,
Mr. Purcell, you all didn't raise this for almost a year. And so it seems, a little disingenuous that all of a sudden now, it's such a critical issue when during the course of the receivership, there was never any motion to require the inventory or objection to the failure to file the inventory.
Judge, the final judgment was on appeal, and it was only at the end of 2018 when my client changed counsel and the receiver filed a motion to get discharged, and this hearing took that long.
No, but during the course of the proceedings, when the receivership was ongoing, that was well before the final judgment of dissolution of marriage.
Yes, absolutely.
And at no point during that entire period of time was there any objection to the failure to file an inventory.
Well, there's two answers to that, Judge. You're correct, but the former husband's exhibit 1 and 2 here show that back in when the receiver had been in the receivership for 2 months and before the court entered its first order after appointing the receiver specifically advised my client and his counsel I know you've got this inventory and hold on to it. We'll get to it. And then not even 6 weeks later, a month later, he testifies, the receiver testifies that he can't get any cooperation from my client because he still has the inventory. Now, this is part of the ongoing process with this case that really needs to be put in context. You're right, a formal objection was not filed to the end of 2018. The background for this is that this company was the sole source of support for both of the parties. My client was running the company, and then the former wife locked him out, changed all the accounts, and from April, I wrote the dates down to make sure, April 2017 until December, she has complete control of everything. And then the receiver gets appointed. Then we have the email.
But let's listen. Both parties in this case have unclean hands. Your client, takes inventory out of the business, forms a competing company, and that's, you certainly can't say that he comes into this with clean hands.
No, but I can also explain the context for this. He did not really start a competing company. What he did was he took the things that were supposed to be shipped to clients, and at the beginning of this, he was supposed to keep running the company, and it didn't happen, and he wanted to make sure that the business remained viable. He never sold anything. He returned the inventory. The receiver at the hearing below admitted that he returned the inventory, and it was never valued.
Well, the reason that he never sold anything is because the court entered an injunction that prohibited him from competing with the business.
Yes, and it's the same order that said that the wife had gone through $90,000 the week after the receiver was appointed to pay her attorneys and funnel money to her father. I understand your point, but the reality is, okay, both parties have unclean hands. My client returned the inventory. There was no loss to the company for any of this, and there's no provable loss for any of this. I'm not trying to re-argue.
That is not an undisputed fact.
That he returned the inventory?
There was a dispute as to whether everything had been returned and what had been taken.
The receiver admitted that he returned the inventory, and I can give you the transcript site if I need to, 110 through 113. But what I consider disingenuous is that the receiver testified that he wasn't sure whether that was all the inventory because my client's list didn't match the wife's list. That makes absolutely no sense in one hand, and it makes complete sense. These parties have been fighting for 2 years. The reality is the receiver was required to take control of this business, which he did. The answer brief claims that he never came into possession of the receivership property. Well, that's wrong both factually and legally. Factually, the moment he was appointed receiver, he did take legal possession of it. The impossibility argument that's been found by the trial judge to apply. Let's assume that there's a warehouse that has 10,000 cases of widgets, and a receiver is appointed to take control of the warehouse and liquidate them. Receiver gets into the warehouse and it's totally empty. That would be, in one sense, an impossible inventory to file. But on the other hand, if he's my client, I'm telling the receiver, we need to file something called initial inventory. We went to the warehouse, took possession in accordance with this court's order, and it was empty. We were waiting further instructions from the court. That's all that had to happen. Mr. Sunderman, the receiver, said the records were in shambles and I couldn't get cooperation. Well, he took control of something. He managed to sell things. He managed to file tax returns. And not once did he ever tell the parties, this is what I sold, this is what I received for it. And then we still get to this final hearing here that leads to this appeal. And my client has still said, there's 3 bills that I've paid out of $20,000 that I put into this business that you are ignoring. So the receiver says, oh, I paid those bills, and the judge believed him. I accept that fact. That's a given. But what's not a given is that there was never any notice to the parties except for the email to my client and his attorney saying, hold on till the inventory. And then a month later, he testifies that my client's not cooperating. Of course, the trial judge has the right and the ability to determine who's credible. But if you've got one witness with two different versions of things that are irreconcilable, where does that leave us? I say it leaves us in a position where this is not believable testimony and neither one of them can be found as facts. But we've already had the final judgment where Mr. Sunderman testified there was no cooperation. I accept that. But the rule says what it says. And if you look at what actually happened in this case, Mr. Sunderman was in a complete ability from day one to be able to report to the parties and their counsel and to the court of what happened. We say that should have led to his being disqualified as the receiver for not having done that. And that was the motion that was in response to his request that that the court discharge him. And then he claims that because my client objected to an unequal distribution of property, because Mr. Sunderman's testimony, he admitted at this hearing that the wife had $141,000 worth of personal expenses paid through this business that he could account for, but he doesn't know where all they went, except that $50,000 approximately went to her attorneys. We accept that that is a finding, but how do you reconcile that with the final judgment's finding that what my client allegedly stole was $30,000 worth of wire? There's no equity in that. And I'm not trying to re-argue the final judgment, but that leads us to issue 2 here, which is the receiver viewed having to defend his actions as a justifiable expense against the estate that he was put in charge of. And my client was to pay the price merely because he objected. And I submit that there's no principled basis on which you can do that, given the facts of record here. There was nothing filed to ever put my clients on notice. This is what we got, and this is what I sold, this is what we received. How could he compile tax returns without ever doing that? And the answer is he just decided it wasn't important. And I guess the theory is better to ask forgiveness than permission. But
Mr. Grassley, so what is the remedy in that situation? How should we divide up the attorney's fees and the credit for that? I mean, well, it's hard to tell in this case. I mean, both parties behaving badly. So how's the trial judge supposed to parse that out? Because I'll tell you what, when I see impossibility in a judge's order, and I see the conduct being displayed by both parties, and I think about the receiver's job in this situation, it's really a thankless job. I mean, tell me where one party behaved any better than the other.
Well, if you look at the dollar bills, the former wife got massive amounts more money. My client ultimately ended up with no financial benefit from this. He returned the inventory. But the real issue is,
okay, so your client was the one who initially took the inventory.
That's after he was shut out of his only livelihood. He took the inventory to complete an order, and that was the uncontradicted testimony.
And opened up his own business. Was that to complete the order too?
On paper, and he was punished for that. The final judgment has already been affirmed.
So how is this receiver supposed to know that now your client is conducting himself above board?
Because he acknowledged at the hearing below that my client returned the inventory.
After he was forced by court order to return the inventory, correct?
He was told in March of 2018 to return the inventory right after the receiver sent my client and his counsel an email saying, hold on to it. So I accept that. But what is the testimony from Mr. Sunderman? The person that challenged my handling of this is the one that should have to pay my attorney's fees. That, under the case law cited in our brief, is the essence of an attorney fee award that should not have been be made to be borne by my client.
There were 2 things that he testified he needed to hire a lawyer for. One is to file a motion to close the receivership, because neither party did so after a number of months. And the second was because the former wife's lawyer had filed a Duval County case seeking assets from, the corpus. And so he felt in order to protect the corpus that he needed to ensure that a default was not entered as to that. Now, why aren't both of those, the trial court found those to be legitimate reasons for securing of a lawyer. He was allowed to hire individuals, employees, or to hire whom he needed to protect the corpus. And that's what he did. And the trial court found that those were reasonable expenditures.
What the judge found about this Duval County suit was that if my client had filed a motion to discharge the receiver, that this other suit in Duval County probably would have gone away. There is no factual basis for that. And the reality is that was the wife's doing. That
might be relevant too. And I agree with you as to the fact that was taxed solely against your client.
Yes,
but that doesn't necessarily address the legitimacy of hiring the lawyer. It simply addresses who ought to bear the expense of that.
Well, and the bulk of the legal fees incurred were assessed against my client for challenging how the receiver carried out what he did. And I submit, Judge, that there is no sufficient evidence to justify the actual allocation of all the attorney's fees to my client, given the enormity of the disparity between the economic impact of both clients' bad conduct. Before I sit down and wait for my rebuttal, I do need to raise issue 3, which is simply the math calculation. And if I am misunderstanding it, I accept that, but it makes no sense how this was calculated, except to the extent that the receiver paid his attorney out of the corpus before he even got permission from the court, which I say is improper. That may be a harmless error, I don't know, but nobody that I've talked to can figure out how this calculation was actually done. And I'll save the rest for my rebuttal.
But it just, aren't you already sitting down?
Yes, and we should be thankful, Judge.
Okay. All right, Mr. Alexander.
Thank you, Judge. Thank you, Your Honors. May it please the court, Steve Alexander on behalf of John Sunderman, who was appointed the receiver in the trial case in St. Johns County, Florida. I think I know the court's familiar with the fact that Mr. Sunderman was originally appointed the receiver in the case on December 13th, 2017 by the court.
And that was at the request of Mr. Fortini, correct?
That is correct. And that's in the record at SR 58 and 59, the court order. And Sunderman had roughly about 85 days to review the case, see what was going on, and then testify in court on March the 9th of 2018. And in the meantime, as you probably, if you've read Judge Alexander's order that he issued on March the 14th, 2018, in the record at SR 909 to 914, within the first 2 weeks that Sunderman was appointed, the former wife took out roughly over $30,000 of monies from the business, and obviously in violation of prior court orders, in violation of the standing family court order. And then Judge Alexander blitzes the former husband for his conduct. And I'm going to read just a small part of it. I'm on page 2 of that same order. In mid-May 2017, long after the divorce case was filed, and while both parties were under the standing family court order, the husband, while represented at the time by Warren Kingery, proceeded to the marital business and essentially stole computers, software, tools and dies, scanners, raw material, including wire and springs. He then set up a business with a similar name to compete with the marital business. It is inconceivable to the court that his attorney could have allowed him to do it without reporting the matter to the court. The wife then proceeded to take loans of approximately $30,000 from her father, and it goes on from there. And then on page 3, near the bottom of page 3 of the same order, the court underscores this portion of the paragraph at the bottom. Both parties have severely impeded this business, and both parties are either incompetent or unwilling to follow the court orders concerning the marital business. The court can trust neither. And then further in that same paragraph, the court goes on to say, quote, the logical solution is to liquidate the marital business until final hearing. Accountant Sunderman can then testify as to what assets have been liquefied and converted to cash, and after his fee and legitimate debts are paid, the parties can split the remaining assets and then run competing businesses against each to their heart's content. So when you read the rule, Judge Alexander actually did what it says in the rule, 1.620B, second line, it says, every 3 months, you have to do the receivership, the report every 3 months, unless the court otherwise orders. Well, the court otherwise ordered here. The court basically said after Sunderman's been involved in the case 85 days, close it out, sell off everything, pay off all the legitimate expenses, and then see what assets are left. Now let's go ahead and distribute them equally.
Well, that's not the same as an inventory being filed, Mr. Alexander.
Judge, the reason there's no inventory being filed, I go once again to the court order where Judge Alexander says in the order, he couldn't trust either one of them. And when you read the whole context of the order, everybody's stealing here. I mean, the wife is stealing from the corporation right after Sunderman gets appointed and writes out like 5 or 6 checks to the tune of nearly $35,000. This is deep into the case. We're talking about December and January of 17 and 18 when she does this. I read the list of things that he took from the business, that the husband took from the business. And Judge Alexander goes on to say, he actually makes a finding of fact that he could trust neither one. So without written records, without any other documentation, whose word are you going to take for him to write a report? It has to be under oath. When a receiver files, when you read that rule 1.620B, it has to be under oath. And Sunderman wasn't about to write a report and file with the court under oath saying this is the inventory when the court couldn't trust either one. And there were no other documents that really validated it. So if I could take you forward just a little bit, we're past the final judgment hearing on the divorce 3 months later in May, I believe it was, of 18. The final judgment comes out shortly thereafter. Now we're in October of 18, and there's a meeting at John Sunderman's office with Mr. Fortini and Mr. Fortini's attorney at the time, Michael Hines. And that's well documented. He testified about that during the hearing, and Sunderman stated that he was more than happy. He went over everything. Apparently Hines, the attorney, was satisfied with the money that was left, and Sunderman suggested that the money be divided 50-50. Hines even went on to say that he would draw up the motion and file a motion to disperse. Then his client, Mr. Fortini, was absolutely against it. And Mr. Fortini said, I'll never let my wife have a penny of that money. I'd rather it all go to attorneys. That's even mentioned in the brief of Mr. Fortini. Mr. Grassley put it on page 17 of his brief. So this October 18th, there wouldn't have been any attorney fees to pay to Steve Alexander or any other attorney had everybody just agreed to what we thought we had an agreement with on October 18th, 2018 at Sunderman's office. Mr. Fortini's attorney wanted to go ahead and make a final distribution and be settled and done with the case. So did Mr. Sunderman. The only human being that didn't was obviously Mr. Fortini. And so Mr. Fortini subsequently, right after that meeting at Sunderman's office, fires Michael Hines. Obviously, he's not happy with Hines and has no attorney. So this case languishes from October 18th to the 3rd week of December. So 2 months goes by. Neither party at this point, the former wife doesn't have an attorney, the former husband doesn't have an attorney. And when Sunderman gets served with the summons out of Jacksonville, Florida, out of Duval County, he comes to me and hires me to represent, to file the motion, to get the disbursement done, and then to file some sort of response so he's not defaulted in court up in Duval County. And that's how I came in on the case. I think at that point,
Let me
Sonderman had to
ask
do
you,
something
why-
to bring the case back.
Mr. Alexander,
Yes, sir.
why should the attorney's fees for Duval County action for the wife's attorney's fees be taxed against the former husband?
This was the same argument I gave to the court during the hearing, and the judge put it in his order. And I'll make it to the court here. If you kind of take it, there should have been an agreement on October 18th of 2020.
But that's speculative.
No, if you just hear, I promise, I'll make it very quick. 60 days went by and nothing ever happened. And so that gave Duval County, the Duval County case didn't get filed till, if I remember correctly, December 21st. And everybody signed between October 18th and October 31st, the consent settlement agreement. The money would have been dispersed. So December 21st, had Sonderman gotten served, he could have filed a response back saying, there's no money in the receivership. It's all gone, court order, it's all closed out. So there'd been plenty of time to taking care of that. We had over 60 days. It seemed like there was an agreement on the table except for Fortini. And remember Fortini, Mr. Fortini's words were, I'd rather it all go to attorney fees. Well, he's just about accomplished that. That was his goal at the October 18th meeting. Rather his wife and him split that money equally 50-50, which is what Judge Alexander said in his March 14th, 2018 order. That's what he wanted. Judge Alexander put that language in there about after paying all the bills, split it 50-50, split it equally. No, Fortini doesn't want his wife to get anything and tells Sonderman and tells his attorney, I'd rather it all go to attorney fees. Well, he got his wish. 60 days goes by. Now we got to where Sonderman had no choice but to hire me to get the motion to disperse in front of the court and to file some sort of response in Duval County because the money was in his bank account. Sonderman did have control of the money. And at that point, I think he's got to file a response. But that should have been done. This case should have been concluded and over with, in my opinion, by no later than the end of October of last year. So I think the judge agreed with me. And I know the court's well aware of equitable distribution under 61.075. And since this is a dissolution case, and under paragraph 1I, the court considered the intentional dissipation, waste, depletion, or destruction of marital assets by either party. It's right in the statute. And that's what happened. Mr. Fortini, at all costs, wanted to make sure that his former wife got zilch, got nothing, got zero. And for that type of conduct, just to elongate this case, I mean, I think the court hit the nail on the head. Why didn't you appeal the March 14th, 2018 court order? Judge Alexander ordered then that the receivership sell off everything, close down the business, and whatever money the court or the receiver got, pay off the reasonable debts, and then split the money 50-50. They could have appealed that back in March of 18 or April of 18 or in May of 18. They chose not to appeal. Like the court said, the first time they bring it up, it's over a year later. So, I mean, it's just we're way too late at that point in time to start bringing that up. That should have been brought up or appealed a year earlier.
All right. Anything further, Mr. Alexander?
No, Your Honor.
All right, Mr. Gressel, you've got a little over 3 minutes for rebuttal. But it would be help if you unmute.
Be more persuasive, I hope.
And I think I understood what you were saying.
Mr. Alexander and I go way back. I will say with great respect that this is the first time I have ever, in my involvement in this case, which goes back several years now, ever heard of a consent order that was not agreed to. Judge Alexander definitely appointed the receiver, said sell everything and then split it 50-50. This statement that my client was trying to be vengeful against the ex-wife and wasn't going to give her a dime is not accurate and is divorced from its factual moorings. That came about because, and this was uncontradicted in the record, what you've just heard is Mr. Alexander's testimony. And if we were in a trial court, I would ask to be able to cross-examine him. But the statement my client made was when he heard from the receiver that the $20,000 in debt that my client incurred to pay business expenses were not going to be reimbursed to him, that the $141,000 that Mr. Sunderman admitted at the hearing below leading up to this order that she ran through the business account was not going to be, she was not going to have to account for that. That's when he said, I'm not agreeing to her getting more money. This is wrong. I would rather fight about this than let her get away with essentially $200,000 out of this business that I didn't get to see. And I'm left with $40,000 in debt that you don't even recognize that I paid business expenses for. Briefly, on page 15 of the answer brief, Mr. Alexander cites a third DCA case called Frank versus Feller, claiming that strict compliance with the rule is not required. If you read that case, the first time it was raised was when they were fighting about the amount of the receiver's attorney's fee, and it was an 8 or 9 month receivership in which the receiver filed 8 different documents. I find it very interesting that Judge Alexander in March of 2018, and Mr. Alexander read this out loud, this long list of things that my client allegedly stole, and he didn't have any inventory of at all. He couldn't ever tell the parties, this is what we have, what we sold. How could he compile tax returns? The bottom line is that the Duval County suit to claim that no that the attorney's fees incurred in that suit because the wife hired an attorney that she stiffed is beyond a reasonable argument, because the reality is there was no deal. If there'd been a deal, it would have been done. If this had been 50-50, we would not have had an initial appeal, and then we wouldn't have appealed this. But what's come down to is that the former wife, despite the fact that both parties are bad actors, according to Judge Alexander, my client has paid multiple times more of a price for having taken some inventory that he returned. The fact that the receiver never put anybody on notice about exactly what he thinks is missing, and having any kind of other court hearings so that he could complete his job is not defensible under the rule, under any version of unequitable distribution in a dissolution case. And again, I think that it's really beyond any reasonable argument that my client should have had to pay $2,500 to Mr. Alexander. I'm sure it was worth it, but my client should not have to pay for the Duval County suit. Thank you.
All right. Okay, thank you both for your argument, and we'll